Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. There is a notation on the website for the Ada County courts in Idaho. The case styled as Idaho versus Kohberger is closed, and that documents that are currently sealed to the public 7 months after the closure of the case would be released as approved. The docket reveals that 112 days have now passed since Judge Stephen J. Hippler rendered his third court order as to sealed documents, dated October 16, 2025, asking both the state and the defense to provide their objections or non-objections to the potential unsealing of multiple documents that were sealed during January, February, and March of 2025, including evidence sealed in support of multiple in limine briefings. The court, 49 days ago, rendered his order of December 18th, 2025, reflecting the fact under Section A that dozens of documents were to be unsealed without redactions, some over one or the other party's objections, and another section, Section C of that December 18th order, reflected the fact dozens of other documents were to be unsealed with redactions. As of today, not a single document, despite that commitment that they would be unsealed as approved, appears on the court docket. Moreover, the fourth court order that deal with documents under seal, from the motions to suppress and the motion for a Franks hearing, has yet to be released. As of this time, only a handful of documents have been released to the public that were previously sealed from the months of April to July of 2025, with more and more documents being sealed from the public even after the closure of the case, up to and including 2 documents that Judge Hippler sealed in January of 2026. The documents from the in limine briefings include evidence under seal in the trial that never happened. The trial that was to be public in Judge Stephen J. Hippler's courtroom in August of 2025 was canceled the day that Mr. Kohberger stood up in open court and pled guilty, as he did on July 2nd, 2025, over 7 months ago. He began serving his sentence July 23rd of 2025 in an Idaho state prison. He is the only person who has ever been arrested for the catastrophic events that occurred at 1122 King Road on November 13th, 2022, despite the fact that a description of the mayhem that happened within that house seems to lead many, including in mainstream media, to now question if it would be physically possible for one person to have done what the state contends Mr. Kohberger did alone, because no one else has ever been arrested on that dark November day. The in limine briefings include evidence under seal that was apparently crucial to the state of Idaho proving guilt beyond a reasonable doubt, which is, of course, the evidentiary standard that they bore at trial, dealing with such crucial evidence as CSLI, IgG DNA, text messages that were exchanged within 1122 King Road on November 13th, 2022, as well as text messages that went outside of 1122 King Road and that were received from the outside world into 1122 King Road that day. Those text messages have been described as has other evidence in the case, but they have not been released to the public, not the actual text messages. Other in limine briefings include the 911 call that went out from 1122 King Road at 11:56 a.m. on November 13th, 2022, notwithstanding the fact that the state of Idaho contends that the crimes were committed sometime after 4 a.m. that day, nearly 8 hours earlier, without the question asked by the Moscow Police Department, why? Other in limine proceedings include the Amazon records. State has contended that Mr. Kohberger purchased the sheath that played such a central role in his prosecution, as well as a K-bar and a sharpener, and that it was delivered to his home in Pennsylvania a few months before he made the cross-country trip to Pullman, Washington, but the actual evidence has never been released to the public. Other in limine briefings deal with suspect vehicle 1, another key feature in the prosecution of the case, witness identification by bushy eyebrows, and so much more. Those in limine hearings on those motions happened in April of 2025, at about the same time that a man in Texas was filing a petition for writ of certiorari in the United States Supreme Court. A person who pled guilty to crimes that he had been charged with, but in order to agree to the plea deal, he had to agree to waive his appellate rights. What Mr. Hunter, the petitioner in Hunter versus United States, case number 241063, is asking SCOTUS to do is to review the legal standard across the country as to when and how a person who has agreed to give up so many constitutional rights, the right to remain silent, the right to confront witnesses against him or her, the right to present a defense against charges brought by the government, whether state or federal, and the right to a public trial where evidence would be brought out into the public. He was required to also agree not to appeal his conviction. Mr. Hunter is asking for due process to also be included in the legal standard across the country, uniform, allowing a party to be able to, at some point, appeal to a higher court. He has a lot of support. There are a number of amicus briefs that have been submitted on behalf of Mr. Hunter to the U.S. Supreme Court, asking that the court look at these appellate waivers and determine if they violate due process. The Fifth Amendment to the U.S. Constitution is at the center of Mr. Hunter's appeal, which is made applicable to the states through the 14th Amendment to the United States Constitution. Oral argument in the Hunter case will occur March 3rd, 2026, just a few weeks from now, in front of SCOTUS. And the ruling that's expected on or before the end of June may change things so that Mr. Kohberger, who also signed a waiver of his appeal rights, might be able at some point in the future to appeal his sentence and what happened at the state court level, leading to his decision to plead guilty. That may be the public's only hope to find out what happened in the court case, because it does not appear that it's going to come through the court records, given what's been going on in this case over the past few months and the complete apparent standstill of the release of court documents, as the court made the commitment to the people would happen as they were approved. Because in any future appeal that Mr. Kohberger may raise, and there's no indication that he has at this point any intention to do, but given the Hunter case and what may happen as a result of this case, he might. And in an appeal, it is generally not possible to hide items under seal. the evidence would need to be presented to that appellate court to determine if, for instance, a new trial should be ordered. We will continue to keep you posted regarding the status of the release of documents to the public in Idaho versus Kohberger. Until next time, thank you for joining us here today.